Ever wondered if you could pass a real law school exam? Well, today we're going to find out. We are diving into India's new labor laws, but not by reading some dry legal text. Nope. We are going to tackle a real university exam paper on the subject. Let's see if we can ace this thing together. So this right here, this is the real deal. It's a final exam covering India's huge 2020 Industrial Relations Code. And these questions, they aren't just academic. They get into situations that affect millions of real people, workers, employers, all across the country every single day. So the big question is, could you pass it? Let's find out. We're going to break it down question by question and really get to the heart of what this new legal framework is all about. All right. First things first. To pass any exam, you've got to know the fundamentals, right? So we're starting by decoding this new code, getting a handle on the foundational changes that honestly, every worker and manager should probably know. And here we go. Question number 1, straight from the paper. And it's a big one. It's about one of the most heated topics in industrial relations, strikes and lockouts. So what's different now under the 2020 code? Okay, here it is. The single biggest game changer, a mandatory 14-day notice period. This is now required for any legal strike or lockout. This used to be a rule just for public utilities, but now it's for everyone. And think about what that means. It's huge. For workers, sudden walkouts are off the table. But for employers, it gives them this crucial 2-week window to prepare, negotiate, or maybe even challenge the whole thing. Right, so if a strike is supposed to be the absolute last resort, what are you supposed to do first? How do you actually settle a disagreement? The exam asks for the official process. What's the new step-by-step path for resolving a dispute? The code lays out a pretty clear 3-step ladder. First, you try to handle it in-house, through committees with representation from both workers and management. If that doesn't work out, the dispute goes to an official conciliation process with a neutral mediator. And only if that fails can the whole thing go to an industrial tribunal for a final binding decision. Now, let's shift gears and talk about the power of unions. I mean, collective bargaining is pretty much the bedrock of labor rights, so how has this new code changed the way workers can organize and negotiate? The exam paper brings up a really interesting new concept here: negotiating unions. This is a pretty significant structural change. So what exactly does this term mean, and what kind of power does it hold? Okay, so this is a major shift. The idea is, if one single union can prove it has over 51% of workers supporting it, it becomes the sole negotiating agent for everyone. Now, this is designed to streamline things, one point of contact, but you can see how it also creates this high-stakes, winner-take-all competition between different unions. But forming a union isn't always so straightforward. The exam gives us this case study. Workers at a plant are fed up with low wages and unsafe conditions, so they want to unionize. But management starts threatening to fire anyone who participates. It's a classic intimidation tactic. So, if you're one of those workers and you're facing these threats, what does the law say? This is a critical question from the exam. Do you have any legal protection, or are you on your own? And the answer is a clear yes. The code is super explicit about this. It actually lists these kinds of union-busting activities as unfair labor practices. That means workers are protected from being fired for trying to organize, they can take legal action against intimidation, and the whole process of forming a union is legally safeguarded. All right, for this next section, we're getting into the really serious stuff, the kind of workplace events that have a direct and often immediate impact on people's livelihoods. We're going to look at strikes, layoffs, and lockouts. So the exam throws a scenario at us where workers strike without any notice. So what is the correct legal path? Well, as we've seen, you have to give that 14-day notice. But just as importantly, you can't go on strike while any conciliation or tribunal proceedings are active. You've got to follow the process from start to finish. And believe me, the stakes for getting this right could not be higher. A legal strike protects workers from dismissal, and it's a recognized negotiating tool. In a legal strike, though, that breaks all that protection. Workers can face penalties, lose wages, and even their jobs. Following the procedure is everything. Now let's look at this from the employer's side. The exam asks us to define 2 key terms. The first is a layoff, and the key word here is temporary. This happens when the employer, maybe because of a power shortage or something, just can't provide work. The worker is still technically employed. Retrenchment, on the other hand, is permanent. This is when an employer terminates a worker's job, not as a punishment, but usually for economic reasons, like having too many workers. This is the end of the line for the employment contract. So let's just put it side by side to make it super clear. A layoff is temporary, with the chance of being called back. Retrenchment is permanent. The job is gone for good. And understanding this distinction is absolutely critical when you're talking about worker rights and what a company owes in compensation. For our final section, we're moving from procedures to principles, fairness and equality. Because at the end of the day, labor law isn't just about rules, it's about justice. So what does the new code actually consider an unfair practice? The exam gives us this incredibly clear-cut case study. You've got Sarah and Tom. They do the exact same job, have the same qualifications, same experience. Everything is identical, but Sarah earns 20% less. And when she asks why, her manager just says, it's company policy. This leads us to a direct legal question. Is this discrimination? Is company policy a valid excuse for paying a woman less than a man for doing the same work? What does the Industrial Relations Code say about this?
And the answer is an unambiguous yes. This is wage discrimination. The code consolidates and strengthens earlier laws on equal pay, explicitly prohibiting discrimination against women when it comes to wages and recruitment for the same or similar work.
So we made it through the exam. We've seen stricter rules for strikes, new structures for unions, and clearer lines on job termination and discrimination. And it all leaves us with one final big picture question. The goal of these reforms was to balance the rights of workers with the needs of business. The question is, did the code get that balance right? That's the debate that's going to continue long after this exam is over.